Welcome to the deep dive. If you are thinking about starting any kind of modern financial service in the U.S., maybe moving traditional money, fiat currency across state lines, or building a new P2P payment app, maybe dealing in crypto, well, you find out pretty fast that getting into the market isn't simple. It's like this huge two-layered regulatory maze, and the cost of getting in. It's all about rigorous, sometimes really overwhelming compliance.
Yeah, it's definitely not something you just jump into casually. The basic idea from the regulator side is that any business involved in moving money, these are generally called money services businesses or MSBs, they see them as inherently high risk.
High risk, how so?
Well, they worry about them being used for, money laundering, financing terrorism, consumer fraud, that kind of thing. So before you can even launch, you basically have to prove under this incredibly detailed, almost forensic level of scrutiny that your company is solid. Like a financial fortress, really, built to fight financial crime and keep consumers safe.
Okay, let's unpack this. The sheer volume of compliance needed to move money legally in the U.S. Our mission today is to walk you through this regulatory chasm, really. We're going to focus specifically on what it takes to get licensed to transmit money. And we're using New York, the world's biggest financial center, and probably the toughest, as our benchmark for just how complex this gets. We've been digging into the official checklists from the DFS, the actual laws, and all the detailed paperwork needed for both the traditional New York money transmitter license, the NYMTL, and the one for virtual currency, the BIT license.
Right. And we're going to break down those two layers of regulation you have to deal with simultaneously, the federal rules and the state rules. Now, by the time we're done with this dive, you should really get why building this compliance setup isn't just a cost you have to bear. It actually becomes a real competitive edge, something you can defend.
Okay, so when you first start planning to be a financial service provider in the U.S., you run straight into this dual regulatory thing. Two layers you have to satisfy. Let's start with the federal level. This applies everywhere, right? All 50 states?
Exactly. Uniformly applied. Every single money services business, or MSB, has to report first to the federal gatekeeper. That's the Financial Crimes Enforcement Network, FinCEN. This all comes from the Bank Secrecy Act, the BSA.
The BSA. Oh,
Yeah, the BSA is essentially the bedrock law for anti-money laundering, AML, in the United States, and it makes it mandatory for every MSB to register with FinCEN.
Yep.
This isn't optional, it's a federal duty, and the timeline is incredibly tight.
How tight?
You have to get registered within 180 days of establishing the MSB, and that's defined as either when the business is legally formed or when it starts operations, whichever happens first. Missing that 180-day window, that comes with serious penalties. It can completely derail your licensing plans before you even really get started.
Wow, okay, so day one stuff. And what exactly is an MSB according to FinCEN? You said it's broad.
Incredibly broad. It's designed to capture almost any kind of non-bank financial activity you can think of. Our sources clearly lay out the specific activities that mean you have to register.
Such as?
Well, things like issuing money orders or traveler's checks. That's pretty clear. It also covers everyday things like check cashing or currency dealing or exchange, but only if the amount for one person goes over $1,000 on any single day.
Ah, so there's a threshold there.
Right. That $1,000 threshold kind of gives a pass to really small incidental stuff. But, most serious operators are going to hit that pretty quickly.
Makes sense. What about things like digital wallets or prepaid cards? Stored value.
That's an interesting one. Issuing, selling, or redeeming stored value only triggers FinCEN registration if the business also does one of the other MSB services we mentioned.
Okay, so it depends on the mix of services.
Exactly. It acknowledges that, say, a retailer might issue gift cards but isn't really acting like a full-blown financial institution. But, and this is really crucial, if we look at the core activity here, money transmission.
Moving money from A to B.
Precisely. Then we hit the absolute key rule. The $0 threshold. Money transmission requires FinCEN registration no matter what, regardless of the volume. If you move even $1 for a customer as a business, you're a money transmitter. Period. You have to register.
$0. So no minimums, no grace period. Compliance starts immediately.
Immediately, day one. And once you are registered, the work doesn't stop. Registering with FinCEN isn't just, ticking a box. It means you've got an ongoing commitment to keep detailed record.
Right, the record keeping. What kind of documents are we talking about? You mentioned 5 years kept in the U.S.
Yes, 5 years physically accessible in the U.S. First, obviously, you need to keep the completed FinCEN Form 107, the registration itself. But more than that, you need an estimate of your projected business volume for the next year. The regulators use that to figure out risk levels and where to focus their attention. You also need super detailed ownership and control information, like a full map of who actually owns and controls the company right up the chain. They want total transparency.
That ownership info sounds critical, especially connecting federal and state stuff later. But operationally, you mentioned something about an agent list being demanding.
Oh, it's a huge ongoing operational task, especially if your business model relies on, say, a network of physical locations or partners acting as your agents. FinCEN requires an annually updated list of every single agent authorized to sell or distribute your services.
Annually. Wow.
Annually. And it has to be exhaustive. Full address for each agent, exactly which services they offer, their gross transaction amounts, and, this is important, the specific bank where that agent keeps a transaction account for handling your MSB funds.
So you need deep visibility into your agent's banking too.
You do. It forces the main MSB company to keep really close tabs on its entire network all year round. You can't just delegate compliance and forget about it.
Okay, so that covers the federal layer. You register with FinCEN, comply with the BSA, you're marked as a monitored MSB.
Yeah.
But, like you said earlier, that federal registration, it's not a license to actually do business, is it?
Absolutely not. That's a common misconception. And that brings us to the second, much more complicated layer, state-level authorization.
Right, the regulatory onion, as you call it.
Exactly. You satisfy FinCEN federally, but to actually operate, you need specific licenses from each state where you plan to have a physical presence or transmit money to or from. This is what people often call the blue sky problem in finance regulation. You might need licenses in dozens of states at the same time, and each state can have slightly different rules, different requirements.
A potential nightmare. And for this deep dive, we're zeroing in on New York as the toughest example. We're talking about the New York Money Transmitter License, the NYMTL. That's required by New York banking law, right?
Explicitly mandated. The law is very clear. Unless you're one of the few exempt entities, no person or company can sell or issue checks or receive and transmit money without this license. And it's issued by the Superintendent of the Department of Financial Services, the DFS.
Okay, the DFS. And what activities trigger the need for this NYMTL? Is it just moving money?
It's actually quite broad, specifically for activities involving fiat currency. So yes, basic money transmission moving funds between people or places is covered, but it also includes issuing or selling money orders or traveler's checks.
Similar to the federal definition, then.
Similar, but maybe even more encompassing at the state level for actual operation. It also covers check cashing or currency dealing exchange, again, if it hits that $1,000 per person per day threshold. And importantly, it explicitly covers providing and selling prepaid access or stored value and also bill paying services. Basically, if you're acting as a middleman for moving or exchanging physical money in New York, you almost certainly need this license.
Got it. Are there any exceptions? Who doesn't need this?
Yeah, the exemptions are important to note. Traditional, established financial institutions are generally exempt. We're talking banks, trust companies, savings banks, credit unions. They're exempt because they're already heavily regulated under other state and federal banking laws, which are often just as strict, if not stricter. But for pretty much every new fintech company, every payment app developer, every pure play money transmitter, you have to go through this NYDFS process. No shortcuts.
All right, let's get into the application itself, because getting an NYMTL sounds like, well, one of the toughest licensing hoops to jump through anywhere. The amount of paperwork, the depth of the background checks, it really shows the extreme level of vetting New York demands before they let you operate.
It really does. And the first major hurdle you hit is purely financial, the cost. Right off the bat, there's the surety bond requirement. For the NYMTL, you need a minimum $500,000 surety bond. That's $500,000. Minimum.
$500,000, wow. And that's just a bond.
A bond, yes. Non-negotiable. And interestingly, just to show how some parts of this process are still quite traditional, our source material points out that the physical bond certificate has to be physically mailed to the NYDFS office.
Mailed. Okay. But let's talk about that $500,000 bond. It's not just a fee, right? What's it actually for? What does it protect against?
That's a really important distinction. It's not just a cost of entry. The surety bond mainly acts as a safety net for consumers and a proof of liquidity. Think of it like a guarantee fund. If the licensed company completely fails, maybe due to fraud, or it goes bankrupt, or some operational disaster means customer funds are lost, the state has immediate access to that bond money to pay back those affected consumers. It instantly weeds out businesses that don't have serious financial backing or the kind of insurance needed to secure such a large guarantee. It filters out the less serious players.
Okay, consumer protection. Makes sense. Then there are the actual application fees, right?
Yeah.
Fixed costs.
Yep, non-refundable application costs. The sources mention $3,000 just for the NYMTL application itself. And if you're also dealing with crypto and need the BIT license, which we'll discuss more later, that's another separate, pretty hefty $5,000 application fee on top.
So it adds up quickly even before you get approved. What about capital? Do you just need the bond?
No, beyond the bond and fees, there's also a minimum capital requirement. But unlike some states that might set a relatively low fixed amount, New York is different. The superintendent of the NYDFS actually decides the minimum capital you need on a case-by-case basis.
Really? So it varies?
It varies. They look at your business plan, how much money you expect to move, your company's current financial health, the specific services you're offering. If you're planning to handle, say, billions of dollars, they're going to demand a much higher level of operational capital than if you're handling millions. They want the capital to match the risk you're bringing into the New York financial system.
Right, risk-based approach again. Okay, so you meet these financial hurdles. What's next? The company itself gets scrutinized.
Deeply scrutinized. This part is largely handled through something called the MU1 form. That's the main company form, and it's submitted electronically through the nationwide multi-state licensing system and registry, NMLS.
NMLS.
Yeah.
And what's on the MU1?
The MU1 is where you lay out your entire business structure, full details on how the company is organized, who owns it, and, crucially, your financials. And when they ask for financials, they need them validated. Rigorously.
How rigorously?
The application demands the 2 most recent years of audited financial statements. Audited.
Okay, audit is the key word, so not just internal spreadsheets.
Absolutely not. For companies that have been operating, this means bringing in an external, certified public accounting firm to go over your books. It's expensive, it's thorough. If you're a brand new startup, you'll need an initial statement, obviously. But the insistence on audited statements for existing firms just underscores how much weight they place on external verification of your financial health and integrity.
Makes sense. What other company documents do they need?
You need all the standard formation documents, articles of incorporation, bylaws, things like that. Detailed management charts showing who reports to whom. But where they really dig in is the organizational chart. This isn't just a simple hierarchy. It has to map out the ownership percentages for every single person or entity that owns 10% or more of the company.
10%. That seems like a common threshold.
It is. And the chart also needs to show all your subsidiaries, any affiliated companies. They want a complete picture, make sure there are no hidden owners or related businesses that could introduce unexpected financial or operational risks.
Total transparency again. And this all feeds into the business plan.
Exactly. You need to submit a comprehensive business plan. And this isn't like a pitch deck for investors. It has to be a detailed regulatory roadmap. It needs realistic financial projections, clearly defined target markets, your corporate structure laid out, and, critically important, it must include both a written narrative and a visual diagram explaining your flow of funds structure.
Flow of funds. You mean how the money actually moves?
Yeah. Precisely. The DFS needs to be able to trace the money. Every single step. How does a customer give you funds? Where are those funds held? Who has custody at each stage? Who is liable if something goes wrong? They need to understand and approve your entire transaction process from start to finish.
Okay, that's incredibly detailed on the company side. What about the people involved?
Well, if you think the company's scrutiny is deep, the personal scrutiny applied to the key individuals running the show is, well, it's almost unheard of in most other industries. The DFS operates on the principle that a company's financial integrity ultimately depends on the integrity of the people in charge.
Makes sense.
So the license application process puts every key person under the microscope. We're talking officers, directors, and anyone who owns a significant chunk again, that 10% or more threshold.
And how do they vet these individuals? Is there another form?
Yes, there's the MU2 form, that's the individual form, and one is required for every single one of these control persons. If the MU1 is the company's application showing its financial strength, you can think of the MU2 as the mandatory in-depth background check on every key person connected to that company. The requirements are Exhaustive.
Like what? What do they ask for on the MU2?
Okay, they require mandatory personal financial statements from all those 10% plus owners and the top officers. They want to see their personal financial health. They pull credit reports for these individuals. And if there's anything negative on those reports, a past bankruptcy, a major loan default, even significant late payments, you have to provide detailed written explanations and back them up with documentation.
So no hiding past financial trouble.
None. You also have to sign and submit official authority to release information forms. That gives the DFS the legal green light to independently investigate your background.
Wow. Okay. And I heard something about fingerprints.
Yes. Actual physical fingerprints. That's required for all control individuals, submitted exactly how the NYDFS instructs. It's interesting, in this age of digital everything, biometrics,
Yeah.
they still demand physical fingerprints. It really highlights the level of certainty and trust they need to establish before they grant someone access to operate within the New York financial system.
It feels very tangible, very serious.
It is. And perhaps the most complex, time-consuming, and potentially expensive part of the personal vetting, especially now with global business, is the requirement for foreign jurisdiction background reports.
What's that?
If any individual who needs an MU2 form, an officer, director, or major owner, has lived anywhere outside the U.S. within the last 5 years, even for a short time, the application requires you to obtain comprehensive professional background reports from those foreign countries.
And what do those reports cover?
Everything. It's not just a quick check. They need credit history from that country, criminal records, detailed verification of employment history while they were there, searches of global media for any negative press, and checks for any regulatory issues or sanctions in that jurisdiction.
That sounds incredibly difficult to get.
It can be extremely difficult and costly. You often need specialized firms to gather this information, get it translated accurately, and make sure it's properly validated according to DFS standards. It effectively prevents someone with a problematic history from just moving abroad for a few years to try and clean their record before applying in New York. It closes that loophole, but the cost and time involved can be substantial.
Okay, so that intense forensic level of scrutiny applies to companies dealing with traditional fiat currency.
Yeah.
But New York being New York, especially with its focus on finance, they have a whole separate additional layer just for digital assets, right? The BIT license.
That's right. And it's really crucial for anyone in the crypto space to understand this. The BIT license is not the same thing as the NYMTL. It's an entirely separate license, a distinct requirement.
So you might need both.
You might very well need both, depending on your business model. The NYMTL, as we've discussed, covers the fiat money transmission side. The BIT license is this unique regulatory creation governed by a specific regulation called 23 NYCRR Part 200. And it's required for businesses involved in virtual currency business activity, either within New York State or even just with New York residents.
Okay, so who needs the BIT license specifically? What kind of activities?
It covers a range of activities. If your business involves receiving virtual currency, storing it for customers, buying or selling it, facilitating its exchange, or even just transmitting it, basically acting as an intermediary for crypto, you likely fall under the BIT license requirements. So if you're running a crypto exchange or a custodial wallet service where you hold customer assets, or a business that transmits virtual currency, you'll probably need the BIT license. And if your model involves both fiat, like allowing USD deposits and withdrawals, and crypto, then yes, you'll likely need both the NYMTL and the BIT license.
Double the fun. Why the separate license, though? What's different about crypto that demanded its own regulation in New York's eyes?
Well, the existence of the BIT license really reflects the specific anxieties traditional regulators have about virtual currencies. They tend to worry about three main things. First, the speed. Crypto can move across borders almost instantly, which raises concerns about illicit finance moving faster than regulators can track. Second, the volatility. The price swings in crypto create significant consumer protection risks that aren't usually present with stable fiat currencies. And third, immutability, the fact that transactions on many blockchains are irreversible. This makes it much harder to recover funds in cases of fraud or error compared to the traditional banking system with its chargebacks and reversals.
Okay, speed, volatility, irreversibility. And those concerns translate into different documentation requirements for the BIT license.
Exactly. The BIT license application demands specialized information that goes way beyond what's needed for just fiat transmission. They're not just checking your bank balance. They're looking deep into the technical guts of your digital operations.
Like what specifically?
For instance, the BIT license application requires incredibly detailed documentation about your company's wallet structure.
Wallet structure, you mean hot wallets, cold wallets?
Yes, precisely. They want to know the technical details. How do you generate and secure the private keys? What percentage of customer funds do you keep in hot wallets connected to the internet versus warm or cold storage kept offline? What are the exact procedures and controls around accessing funds, especially things like multi-signature schemes that require multiple approvals? It's deep technical due diligence aimed at assessing your resilience against hacks and theft.
Okay, that makes sense.
What else? They also demand your formal, documented methodology for virtual currency valuation. Given how wildly prices can fluctuate, they need to know exactly how you determine the fair market value of the crypto assets you hold for customers. How often do you update this valuation? This is critical for accurate financial reporting and ensuring you meet capital requirements.
Right, because the value of your reserves could change dramatically hour by hour.
Exactly. And beyond the core tech, the DFS wants proof of insurance specifically covering losses of virtual currency. Standard business insurance often doesn't cover crypto. They also require detailed information about any third-party services you rely on, maybe external custodians, market makers, blockchain analytics firms. They want to ensure you're properly managing the risks that come from relying on outside vendors in the crypto space.
And the financial side, is there a bond requirement like the NYMTL?
Yes, the financial commitment mirrors the NYMTL, reinforcing that high barrier to entry. The BIT license also requires a minimum $500,000 surety bond, or alternatively, you can set up a trust account specifically for customer funds, which also needs DFS authorization. And again, proof of that bond or trust account needs to be physically submitted. It really shows them emerging traditional, high-stakes financial oversight with this cutting-edge technology.
So the people involved need extra scrutiny too.
They do. That specialized focus extends right down to the key compliance personnel, those MU2 personal vetting forms we talked about. They are specifically required for the Chief Compliance Officer, CCO, and the main AML/BSA officer within the virtual currency operation. The DFS doesn't just want to see a resume. They demand verification of their specific qualifications and proof of actual experience in managing the unique, heightened risks that come with digital assets. They want to be sure the people overseeing this complex area are genuine experts, not just general compliance folks.
So the BIT license essentially forces crypto companies to adopt the same kind of rigorous, proven compliance standards that exist in the traditional finance world. It's a way to ensure innovation doesn't compromise safety.
That's a good way to put it. It's designed to ensure that innovation happens within a framework that prioritizes consumer protection and the overall integrity of the financial system.
Okay, we've covered the huge upfront hurdles, the money, the bonds, the incredibly detailed background checks on both the company and the people.
Yeah.
But you mentioned earlier that where the regulators really focus their ongoing scrutiny is on the operational side, the actual policies and procedures. This is where you prove how you run things day to day.
Exactly. Think of these policies as the core intellectual property of your compliance program. They are the detailed user manuals that demonstrate your operational rigor. This is less about getting the license and more about keeping it and operating soundly. And it all starts with the absolute foundation required by both FinCEN at the federal level and the NYDFS at the state level. A comprehensive, well-documented anti-money laundering, AML, and counter-financing of terrorism, CFT program.
AML-CFT, that sounds standard for finance.
It is. But the key here is that it must be risk-based. It can't be a generic off-the-shelf policy. It has to be specifically tailored to the unique risks presented by your business, considering your specific customer base, the countries you operate in or serve, and the particular products or services you offer.
And the core of that AML program is KYC, right? Know your customer.
Precisely. KYC is the heart of it. And it's not just checking an ID. It mandates detailed, often multi-layered procedures for several things. First, robustly verifying the identity of every single customer. Second, having a formal process to assess each customer's risk profile. Are they potentially a politically exposed person, PEP? Are they interacting from a high-risk country? Third, identifying the ultimate beneficial owners if your customer is a company, not just an individual. And fourth, conducting ongoing monitoring of customer transactions and behavior to spot anything unusual or suspicious that deviates from their expected activity. This isn't a document you write once and file away. It has to be a living, breathing, continuously updated operational program.
Okay. And New York adds something extra here, specifically for transaction monitoring.
Yes, New York has a particularly demanding requirement which applies to both fiat and crypto businesses under their Part 504 regulation. It's called the Transaction Screening and Filtering Program. This is where compliance becomes truly real-time and technology-driven.
Part 504. What does that require? specifically?
Part 504 mandates that the business must ensure every single transaction flowing through its system, whether it's an outgoing wire transfer, a crypto withdrawal, or even issuing a physical money order, is screened against various sanctions lists. The most critical lists are those maintained by the U.S. Treasury's Office of Foreign Assets Control, or OFAC, but it often includes other lists too, like UN or EU sanctions.
Every single transaction. What's the operational lift for that?
The operational burden is immense. This can't realistically be done manually or even in batches after the fact. It demands sophisticated technology. You typically need to implement real-time API connections to specialized screening vendors who maintain constantly updated global sanctions lists. The system has to check the sender, receiver, and sometimes intermediaries against these lists before the transaction is processed. If there's a potential match, the system has to flag it instantly, halt the transaction, and trigger an investigation by your compliance team.
What about false positives? Common names hitting the list.
That's a huge challenge. The system and the procedures need to be smart enough to efficiently clear false positives where, say, a common name matches a sanctioned individual, but it's clearly not the same person without creating massive delays or friction for legitimate customers. But you also need a perfect, auditable trail documenting exactly why each transaction was either cleared or blocked. A failure in this screening process is a direct, serious regulatory violation and could lead to enormous fines, especially from OFAC.
Okay, so that's tackling financial crime. What about protecting the systems themselves? Data security.
That's the other major pillar, especially in New York. It's codified under their groundbreaking Part 500 cybersecurity regulations. Given that New York is home to the world's most critical financial infrastructure, the DFS mandates a very robust IT security policy to protect sensitive customer data and ensure the operational integrity of the financial institution's systems.
Part 500. What needs to be in that IT security policy?
It's highly specific. The policy and the underlying controls must cover several key areas. Things like strong access controls, who gets access to which systems, databases, and sensitive customer information, and how is that access managed and monitored. It requires detailed business continuity management, or BCM plans. What happens if there's a disaster, a hurricane, a major power outage, a cyber attack? How does the business continue to operate, settle transactions, and recover systems?
So disaster recovery planning is mandated.
Absolutely. And closely related are incident response protocols. If you do suffer a data breach or a successful cyber attack, what are the exact steps you take? How do you contain it, investigate it, and crucially, how quickly and transparently do you notify affected customers and the regulators themselves? And finally, it demands rigorous vendor management. You need policies and procedures to ensure that any third-party vendors you rely on, cloud service providers, payment processors, software developers, also meet high security standards, because you're ultimately responsible for the security of your customer data, even if a vendor causes the breach.
That third-party risk seems huge these days.
It is, and the DFS knows it. Critically, though, they don't just take your word that you have great policies. Our sources emphasize a mandatory testing requirement under Part 500.
Testing.
Yes. You have to provide documentation showing the results of comprehensive cybersecurity testing. Specifically, they require regular penetration testing where you hire ethical hackers to actively try and break into your systems and vulnerability assessments. You have to give the regulator the reports from these tests, proving either that your defense is held up or detailing how you fixed any weaknesses that were found. This goes way beyond just writing policies. It demands real-world proof that your security actually works.
Proof of strength. But what about managing the broader ecosystem like those agents we talked about earlier?
Right. If your business model involves using a network of agents or maybe correspondent partners to facilitate money movement, the DFS requires extremely detailed policies governing those relationships too. These agent and correspondent policies need to cover the entire life cycle. How do you vet and select agents? What do the contracts look like? What are the standards for record keeping at the agent level? How do funds get remitted back safely and promptly? What are the compensation structures? The regulator wants absolute assurance that the licensed MSB maintains full control and oversight over everyone acting on its behalf. They want to close off any potential loopholes for fraud or sloppy practices happening out in the network.
It really sounds like the entire application process is designed to be like a preemptive, incredibly thorough audit of your whole operation.
That's a great way to think about it. By demanding all of these detailed policies, validated financials, background checks, testing results, and organizational maps up front, The regulator essentially forces the applicant to build a fully compliant, operationally sound system before they even get the license. You have to be ready for ongoing compliance from day one. And managing this massive application effort itself requires constant communication with the regulators. You need a dedicated team ready to respond quickly, accurately, and completely to any questions or concerns the DFS examiners raise during their review. It's an intense dialogue. So we've just walked through this, frankly, monumental list of requirements. The money, the bonds, the deep dives into personal histories, the complex policies, the testing. The immediate question any rational business owner or investor asks is, why? Why put yourself through this level of pain and expense when there are, other states with seemingly easier requirements?
Exactly. What's the payoff for all this effort? This gets to the so what,
Yeah.
the strategic value. Right?
Yeah, precisely. And here's where it gets really interesting. Because the difficulty, the sheer rigor of the New York process is the value proposition. New York isn't just some random state. It is undeniably the largest, most important financial center and market on the planet. Operating legally in New York gives a company instant, globally recognized credibility.
Credibility that you wouldn't get from, say, a license in a smaller state.
Not to the same degree, no. A New York license, whether it's the NYMTL or the BIT license, acts as a signal to the entire global financial community. It says this company has been thoroughly vetted by one of the most demanding regulators in the world. If you've successfully navigated the NYDFS due diligence gauntlet, you have, by definition, built a compliance infrastructure. Your technology, your policies, your people, your governance, that has been battle-tested and validated against the industry's gold standard.
So the pain is the gain, essentially. The validation itself is the asset.
In many ways, yes. That DFS validation creates a powerful competitive moat. For any company operating in the high-risk space of money movement or digital assets, the value isn't just the license certificate itself. It's the implicit certification of your operational maturity and robustness. This validation is incredibly valuable when you're talking to potential investors, seeking banking partners, or trying to establish relationships with international financial institutions. It immediately signals that you are a lower-risk counterparty.
And does that New York validation help with getting licenses in other states?
It often does. This seal of approval frequently acts as a kind of de facto regulatory passport. While you absolutely still need to get licenses in every other state you operate in, having the New York license can significantly streamline the process elsewhere. Many other state regulators, especially those with smaller teams or less experience in complex fintech, may rely heavily on the groundwork already done by the NYDFS. They might accept New York's vetting as sufficient proof for many requirements, leading to faster approvals and lower costs for multi-state expansion. It gives you momentum.
And what about banking? We hear constantly about how hard it is for fintechs, especially crypto firms, to get stable banking relationships. Does the NY license help there?
Exponentially. This is one of the most critical, practical benefits. Banks themselves are under immense regulatory pressure to manage risk, particularly AML risk from their customers. They are far, far more willing to provide accounts and services to an MSB that is licensed and supervised by a top-tier regulator like the NYDFS, because that license demonstrates proven AML KYC controls. An unlicensed entity, or one licensed in a perceived lighter touch jurisdiction, faces a much harder battle securing reliable banking. And reliable banking access is the absolute lifeblood for any money transmitter or financial service provider. The New York license helps secure that lifeblood.
Okay, so the strategic value is clear credibility, easier expansion, banking access. But it's not just about the license itself, is it? There's a bigger picture.
Absolutely. You have to look beyond just obtaining the license document. Getting the license is really just step one. A truly successful strategic approach in this complex environment means taking a much more holistic view of your entire operational and corporate setup.
What does that holistic view include?
Well, the decision to even apply in New York needs to be part of a broader strategy. That includes careful jurisdiction selection, where should you legally domicile the parent company for regulatory and tax reasons. It involves planning for tax efficiency across different states and potentially internationally. It means thinking about the most effective corporate structure to provide clarity to regulators and manage liabilities. It obviously includes proactively securing those vital banking relationships we just discussed. And it means constantly monitoring and mitigating the political and regulatory risks that are always shifting in the financial technology landscape, especially around digital assets.
So tackling the complexity of New York licensing isn't just a compliance task, it's a fundamental business strategy investment.
Exactly. It's a calculated investment. You embrace the high regulatory bar, what seems like a restrictive burden on the surface. The cost, the time, the scrutiny actually transforms into a highly valuable, defendable competitive advantage. It elevates your business, protects it, and sets it apart from competitors who might choose seemingly easier, cheaper paths in less rigorous jurisdictions. Those competitors might save some money upfront on compliance, sure, but they often pay for it down the road in terms of limited credibility, difficulty accessing partners, and restricted growth potential. #outro.
Okay, let's quickly wrap up the main points from our deep dive today. Operating any kind of financial service in the U.S. market requires this massive dual-layered approach. First, you've got the federal requirement. Register with FinCEN under the Bank Secrecy Act. Key things there are the $0 threshold for money transmission and that strict 180-day deadline. Can't miss that.
Right. And second, you need state authorization. We used New York with its NYMPL and the separate BIT license as the benchmark for just how rigorous that can be. And supporting both those layers is the incredible amount of documentation and proof required. The big financial hurdles like the $500,000 surety bond, the deep forensic vetting of individuals through the MU2 forms, needing personal financials and even physical fingerprints, and proving your operational strength through detailed AML KYC policies, real-time Part 504 transaction screening, and those mandatory Part 500 IT security tests.
Oh, it's a phenomenal barrier to entry, no doubt. But as we discussed, navigating it successfully creates this powerful market advantage. We connect this to the bigger picture. The ongoing regulatory uncertainty around digital assets and all the new payment technologies just makes having this kind of established, validated compliance even more valuable. Proving your systems against New York's gold standard brings stability, resilience, and a real edge in the market.
Absolutely. And just as a final thought for you to consider, remember that FinCEN registration requirement for the annually updated list of all your agents, the one that needs their addresses, services, transaction amounts, even their bank account details. Given that ongoing annual requirement, what kind of recurring operational risks and burdens does that place on a licensed business, even after they've jumped through all the massive hoops to get the license in the first place? It suggests that compliance is never really done. It's a constant, never-ending process of oversight and investment.
Something for you to mull over as you navigate these complex regulatory currents. Thanks for diving in with us today.
See you next time for the next deep dive.